Call the third case on this morning's docket, case number 110149, State of Kansas v. Corey.
May it please the court, Peter Meharry for Ralph Corey. If I could have 3 minutes of my time for rebuttal, Your Honor.
3 minutes is granted.
Thank you. This case comes before this court on a petition for review. Mr. Corey was convicted of several offenses, the most severe being an aggravated kidnapping. He was subsequently sentenced to 401 months incarceration. On appeal, we raised, I believe, 6 issues before the Court of Appeals. While the Court of Appeals found that there were errors at the trial level, it ultimately affirmed his sentencing conviction. We have carried forward those issues in our petition. And if I could, what I would like to do is start with the third issue, which is the instructional issue, and then kind of work my way back around to the first issue and, time permitting, maybe the second issue. The third issue deals, as I said, with instructions. In this case, the court gave a couple of instructions that we have asserted were improper. And the Court of Appeals agreed with us on that, finding that the preliminary instruction and also instruction to the jury during deliberations were improper. Specifically, the preliminary instruction, the district court instructed the jury that when talking about juror misconduct, it stated a mistrial would be a tremendous expense and inconvenience to the parties, the court, and the taxpayers. Later on, during deliberations, when the jury was recessed for the weekend, the district court again gave an instruction in which it stated, a mistrial means we would have to try this thing again. There would be 12 more of you selected and another cost associated with that for a week-long jury trial.
To clarify, was that after the court became aware that one juror had said it was a retrial?
That was, the instruction was given after, Your Honor.
Okay.
As the timeline goes, the jury apparently was having some issues, and they had asked the bailiff about going on a break. While the bailiff was back with the jury, kind of organizing their break, a juror indicated that, I don't know if it's a he or she, but that juror indicated this was a retrial. At least a couple other jurors indicated they were not aware of that. And as the bailiff indicated that this statement was made back in the jury room in the presence of all the jury. At that point, the bailiff went and talked to the district court. The district court went back in by itself to the jury room and told the jury to stop deliberating and that it needed to discuss the matter with counsel. After discussing it with counsel, essentially they agreed that they were going to take the weekend to think about it. Defense counsel was considering a mistrial at that point. And it was at that point when the district court recessed the jury for the weekend that it gave this second instruction, again talking about the cost associated with a mistrial. As I said, the court...
You would agree that since the Court of Appeals found that instruction was error and the state didn't cross-petition, we're really just talking about reversibility at this point.
I would agree with that, Your Honor. As I said, the Court of Appeals found several errors in this trial. The state did not cross-appeal on any of those. And I think the issue before this court is whether or not, in this issue, whether or not those instructions warrant reversal. And we believe that they do. We believe that it was highly prejudicial given the underlying circumstances, given the fact that the jury knew this was already trial number 2. And you have the district court, both in preliminary instructions and during deliberations, when they are, as the court said, struggling to get along, again telling the jury, look, if we have to do this again, that's another cost. That's another expense on us. It's going to take another jury of 12 to sit here for a week to do this. So we think it puts a lot of pressure on the jurors, basically pushing them to convict in this case. So, you know, in this regard, and I know Taha certainly was my case, I'm certainly aware of that, where this court found the preliminary instruction was okay. But again, I think we're still just dealing with reversibility, and I would.
Well,
argue
how
that
can this be reversible in light of Taha? Even if we decide that we're not looking at the Court of Appeals determination on error, I mean, you still have Taha out there.
Sure.
And so how could this be reversible?
I think the facts in this case are very much dissimilar from Taha. Taha dealt with just the preliminary instruction. That was the only time the issue of the cost and expense came up in that case. In this case, there was a second instruction right during deliberations, in addition to the fact that we know the jury was having issues. The district court itself said they were basically close to yelling at each other. And finally, in this case, we know that the jury knew that this was a retrial. This was already trial number 2. Taha, my memory serves, was actually a retrial as well. But there is no indication that the second jury knew that. So we have a jury that knows we're already second go around, and while they're struggling in deliberations, the district court then instructs them again about the costs associated if they can't reach a verdict and there's another mistrial. So I think those facts from this case distinguish it from Taha.
Is that correct? Did the district court ever instruct the jury about costs if the jury couldn't reach a verdict? Or was it always the cost? I mean, we are talking about the costs associated with the mistrial, but
Right.
Was it in the context of juror misconduct, or was it ever in the context of if you guys can't reach a verdict?
My recollection, Your Honor, is that I think it was a Friday when the district court was recessing him, he was talking about his admonition to the jury about what they could and could not do.
That was my recollection as
Yeah.
well.
So if I said it was otherwise, my apologies, Your Honor.
But go ahead.
But the instruction still contains what we see as the problematic aspect of it when the court is bringing up that there would be.
My notes, Counselor, I'd written a quote down here. Cost associated with that for a week-long jury trial. The court, end quote. That's what the court was emphasizing, the cost associated with the week-long jury trial.
That
What he admonished. And he didn't say that cost was different if it was a hung jury retrial or juror misconduct retrial. He didn't differentiate on what kind of retrial it would be, did he?
No. The instruction and the quote I have is a mistrial means we would have to try this thing again. There would be 12 more of you selected, another cost associated with that for a week-long jury trial. So it's important. I guess I can't just stress it enough. That was the instruction. And again, going back to the timing of that instruction, it's during deliberations when we know the jury is having issues. And the fact that we know the jury knows this is the second go-around.
But isn't that in and of itself an indication of the prejudice that can flow to a defendant even on a retrial because of juror misconduct? In other words, the very fact that it was juror misconduct in referencing the first trial indicates that those instructions that are intended to emphasize to jurors how important it is not to commit misconduct they redound to the benefit of the defendant, don't they?
The way I read this instruction, that does not go to the benefit of my client.
Well, your client did. It wasn't a benefit to him that the second jury became aware of the first case. I mean, that clearly wasn't a benefit, right?
Right. So I apologize. I don't know if I'm following your question, but
That's probably my fault for not asking a good question. Let me try again. One of the distinctions in Taha was sort of asking the question, what's the reason for this instruction? Why is the judge giving this instruction? And we talked about there's an inappropriate reason to give this kind of instruction, i.e. coercing a hung jury to come on, get your act together and give us a unanimous verdict. That's an inappropriate reason to give that instruction. However, to guard against juror misconduct is appropriate because, in fact, juror misconduct hurts not just the state, but it can also hurt the defendant. And we said that's an appropriate reason to give this admonishment.
in Taha, certainly this court did.
And so just put this case on that spectrum somewhere for me.
I think this is pushing the jury to convict, to avoid having to redo this again, to avoid having those costs associated with that. And again, I can't emphasize enough the timing of the second instruction right during deliberations, right before the jury is recessed for the weekend. We think that the timing of that second instruction, again, emphasizing the cost of a mistrial, when you combine it with the issues the jury was clearly having, and the fact that they knew this was the second go-around, makes this very prejudicial to my client and do warrant reversal.
Was
And
that instruction
refresh-
part of the original jury instructions given at the close of the evidence?
I don't believe it was, Your Honor.
Okay.
This was I don't know if the
That
court had,
you know, the Allen instruction, do you know if it was given in the packet?
the one in the deliberations, I do not believe was in the package that was given to the jury initially. I think this was, courts give the admonishment every
Right,
time
is
they
this a
break.
kind of an addition to the
And I
admonishment?
think he expanded on that, and that's how this instruction came to the jury.
So these instructions were given basically at the front end of the trial, at the end of it.
That's correct,
Very
Your Honor.
deep.
Very close to the end of it. The jury did recess for the weekend. They came back Monday, and they voted to convict later on Monday. When you have it at the start and you emphasize it in the beginning and the end, we think the prejudicial effect is even greater than what we would have saw in Taha.
Can I move you over to prosecutorial misconduct?
Sure.
We've still got some time. You've got two aspects of that. One's a misstatement of law, the other's a misstatement of fact, and I want to talk about the latter.
Okay.
Your mistake of fact. And that has to do, as I understand it, with a statement that the defendant's DNA is on the victim's stomach, right?
Correct.
Why isn't that a reasonable inference based on the evidence?
I think our problem with that comment is that when you look at the DNA evidence and the way we believe the prosecutor presented it, I think are two different things. The DNA evidence was contested, and certainly the DNA evidence with regard to what was found on the belly of the victim was, I believe the testimony was 1 in 9. But I think when the prosecutor basically gets up there and says, it's his, and that's not a direct quote or anything like that, I think he goes beyond arguing the evidence and reasonable inferences from it.
Would you agree that in trying to decide whether the evidence allows the prosecutor to reasonably infer the fact that he's declaring or she's declaring, the other evidence gets thrown into the mix as well? It's not just that it was a 1 in 9 DNA, and so you're kind of maybe overstating the math, but there are other things in evidence that might also contribute to the prosecutor believing that the DNA is the defendant's.
Certainly there was other DNA evidence from the hat and the gloves, and obviously other evidence at trial.
And there's two witnesses, too, that kind of put the defendant on the scene. It seems like that goes into the calculus, doesn't it?
The problem I have with that is, in my recollection of the record, is the comments we're complaining about, the prosecutor was very specific about the DNA evidence he was talking about, and that he made the DNA evidence on the belly, it's his. If he would have said, you look at the DNA evidence that we obtained from the hat and the gloves, the DNA evidence from the belly and the testimony of the witnesses, he's the guy. I think that's different than what he said in here when he was focusing on the DNA evidence on the belly, which only came back with a 1 in 9 probability or whatever term they use.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers.
Ms. Chalmers, before you get going, I want to make sure that we've got the issues in front of us. As this case comes to us today, we already have, and because the state didn't file a cross petition for review, the Court of Appeals found on the mistrial motion, or the mistrial issue, that a fundamental failure in the proceedings had occurred. So that issue's established, correct?
I have an argument on why I can still get there without a cross petition, but without hearing that argument, yes.
Okay. We also have a determination that the trial court erred because the defendant wasn't present at the discussion of the jury question, the read back, and then the ex parte communication, correct?
The defendant didn't preserve in his petition for review the ex parte communication with the jurors. It's not in his petition for review. But the others, yes, the jury did make that error finding, or the court did make an error finding.
The court did what?
The court made an error finding on all of those, but it's not in the defendant's petition for review.
As to whether that's reversible?
As to whether that's reversible on by itself, it is in the cumulative error analysis.
Okay, and then the third thing was the jury instruction about the cost of the mistrial. That was already determined to be an error, so that's off. That part's off the table, and we're just to reversibility, right?
That was found to be error, yes.
Okay, now, so make your argument
Okay.
that there's a reason why we can hear those, even though
I did not
no
file-
one challenged
yes.
it.
Even though there was no cross petition for review, it is the state's argument that the state is not seeking any broader relief than it obtained in the Court of Appeals. The Court of Appeals affirmed the convictions in this case. That's what the state would like this court to do. This court is more or less an error-correcting court, and KSA 6261 prevents reversal if there's no error, or if there's no actual, well, reversible error, essentially, because there's no prejudice to the defendant's rights, and there can't be a prejudice to the defendant's rights to require reversal if there's no actual error. So under KSA 6261, and because we're not asking for any relief more than what we've obtained in the Court of Appeals, we would argue that you can't redetermine whether or not errors were actually made.
You're saying
So-
if we know there was no error, we can't reverse. That's what you're saying. Right?
Yes,
Even
and-
if you didn't petition for review of that.
Correct, because the trial court is right for any reason. Going to the juror instruction mistrial, I do think this is basically controlled by Taha. The instruction was given so the jurors would not commit misconduct again, and done after basically the jurors, one juror mentioned that they knew it was a retrial.
But this is pretty much different than Taha. In Taha, the rationale was that was appropriate because juror misconduct causes all kinds of mischief, and so the end justifies the means here of misdirecting the juror to consider cost because it's going to benefit everyone. But that didn't work here. That initial admonition was given to the jury before trial, correct?
Correct.
And then we have juror misconduct during deliberations. So we already know that the admonition didn't do what it was supposed to do, and then the court gave the admonition again, directing the jury to consider the cost when as part of their consideration. So why isn't that different than Taha?
I would agree that it's different because there is something that happened, and slightly different. I still think Taha's controls. But the judge is still instructing the juror, do not commit misconduct. Don't do any research. Don't do any of this that would cause a misconduct. There had not been a finding of juror misconduct. I don't think the jury discussing irrelevant things is per se misconduct. And it was, I'm not even sure there was a finding of a juror misconduct, just that they had a fact outside.
Was that in the record that this is a retrial?
Should the jurors have known that? It wasn't presented as evidence during the trial, no.
So that's considering matters outside the record,
Correct.
and they were told not to do that,
Correct.
and not to inject personal knowledge into the deliberations. So how can you say that may be not juror misconduct?
Because I don't know that they were actually using that as a reason to meet the state's burden. If they say, well, I'd like chicken today for lunch, that's something they're saying during deliberations that wasn't part of the evidence. I get that it's different. I do. But here, they were then again told, so any problem that they had, that was cured by the jury instruction that says you can't consider any prior proceedings. It is absolutely not to be considered in determining whether or not the state met its burden. And that instruction, again, was to coerce them not to commit, I guess, further misconduct, if you believe there was misconduct, or any misconduct at all, to not have to do a retrial because of the jurors' actions. I think the same result in Taha should occur here, but even if there is an error, I don't think it amounts to reversible error.
How does a juror know to compartmentalize the admonition about the cost associated with a week-long trial? That is bad if it's caused by juror misconduct, but it's not bad if it's caused by one or more holding out with a different verdict.
Because it's not linked for them in the jury instruction, the Allen instruction is different. That's linked to you have to do a unanimous verdict. It's actually in the Allen instruction, the taxpayers is linked to how they come and reach their verdict. That wasn't done here. This was linked to juror misconduct. I don't think there's any reason they would have gone off on that train. There's also no indication that the jurors here were deadlocked after the weekend where they just needed a break. They got their break. There's no indication that they were deadlocked or had any issues reaching a verdict. They actually had a read back because they wanted additional evidence. They sat through an hour or some odd hour or two read back of the DNA evidence in this case, and then they reached their verdict. I don't think there's any indication here that the jurors reached a verdict because of this instruction.
What can we make of the supplemental brief that the state filed to go into this business about having a ex parte proceeding with the district court while this case was on appeal to decide whether the defendant was present, when the defendant wasn't even present during those proceedings? I mean, is there anything we can do with that?
I think that at this point, there is at least, I mean, it's supposed to be, what I would like this court to do is set aside its case law that says if the defendant's not present, you presume he's not there, or if it's not in the transcript, you presume he's not there. That would be nice. If you would also not make it reversible because he wasn't present without a remand, because the state's not, if there's no error here, or if it's not reversible error, you don't even have to get there. You don't have to deal with anything about this ex parte hearing, which I do think the state was attempting to follow Kansas Supreme Court Rule 3.04. I don't know that I'm getting that number exactly right. And they were trying to recreate the record. There was an error in the record. Everyone knew. The judge knew. The court reporter knew. The prosecutor knew. And the defense attorney knew. The defendant was present for the readback and the discussion of how to do the readback. So at this point, if you reverse, you're reversing when everyone knows. There's no evidence to the contrary, and it's supposed to be a rebuttable presumption that the defendant wasn't present. We attempted to rebut the presumption. We might have done it wrong, but then in front of this court, we tried to do it right. We tried to do a remand, and this court said no. So the state, in its brief, also admits that with the benefit of hindsight, yeah, the defendant should have been present. They did it wrong.
The district court didn't even have jurisdiction to do anything because the case is up here.
Well, I think Rule 3.04 is somewhat confusing to practitioners for the most part in that what are we supposed to do when there's an error in the record? The district court loses jurisdiction to correct errors. That doesn't make any sense to us. But if that's the way this court is going to interpret its rules, that's the way they're going to interpret the rules. You're going to interpret the rules. So they tried. They tried to prove that he was present, but here I think based on the readback itself, it doesn't matter. The error isn't reversible. But I would urge this court to not basically allow defendants to assert claims that with investigation we could easily prove if they're true or false and then get reversal based on that claim when we can prove that the defendant was here. And we can do it the right way with the defendant being present if we have to. Are there any
If the defendant fails to make a record, should the defendant get to get a remand to establish what the defendant wants to? Very often we say, no, you lose. You may have said you want a continuing objection at the bench, but if it's not on the record, you lose. Would that work both ways, that when someone claims something happened but didn't make it on the record, they get a remand? Or how do we choose who gets remands to make the record?
Well, typically, except for in this circumstance and I think jury waivers, we presume that there was no error. This is an exception where we presume error based on a silent record. So we're asking for, if you're going to have a strange presumption where we're going to presume error and no error actually existed, we get a chance to refute that. Because again, 6261, you can't reverse if the error is harmless, or you shouldn't reverse if there's no error. And I think
That's
both
for
parties.
state claims.
I'm sorry.
That's for state-based claims, correct?
State-based claims. I think
Not
it's.
federal claims of error, but state-based.
I don't know that I've thought there was a distinction between the two. This is a constitutional-based claim too. But if it's something we can prove, if it's something we can prove with a remand, we should get to prove it with a remand. I believe there are cases when there are other cases where the court remands because we don't know what happened. And Moyer is an example of a remand where this court remanded because there wasn't sufficient discussion about the conflict of interest between the defendant and his counsel. Remands happen all the time when we're not sure, but for some reason in this context, the court presumes error, and I would basically strongly ask this court not to presume error, especially in something that is provable, one way or the other.
I'm going to move you over
Okay.
to the second claim, or the first claim of prosecutorial misconduct that we didn't discuss, and that's the legal issue about whether a voluntary cessation qualifies as an attempt under the plain language of the attempt statute. In other words, the failed or failed in the accomplishment of the crime, why that includes a voluntary cessation.
The attempt is met when you make the overt act toward committing the crime. It was done then. You can't stop doing
But
something
that isn't what
was
the
done.
statute says. The statute doesn't say you attempt when you make an overt act. It says you make an overt act and then I can't remember the language, but you fail to complete it. And the second part of that is what I'm asking about. Why does that include a voluntary withdrawal?
You still failed to complete. I mean, it doesn't say you failed to complete because you
We're prevented from doing so.
were prevented from doing so. In that case, I just think based on the statute, this is clearly fits within, and the prosecutor didn't make a misstatement of law at all. There's certainly no case law to this so far that says that voluntary abandonment is an actual defense, so couldn't have been gross and flagrant, couldn't have been no will. Unless there are further questions, the state would respectfully request you affirm the convictions.
What about the prosecutor's statement on the DNA? He or she, I don't recall which, the prosecutor said pretty clearly, as I read the record, the defendant's DNA was on the victim's body. Why isn't that a fact outside the evidence? There was no evidence that the defendant's DNA was on the victim's body.
There was the DNA evidence, the 1 in 9 probability that the DNA found in the stomach was indeed the defendant's. Coupled that with all the other evidence, the DNA evidence.
Right, but that's not what the prosecutor argued. The prosecutor said defendant's DNA was on the victim's body. And he could have said, and I think actually he did say earlier in the argument that DNA was found to be a 1 in 9, that only 1 in 9 matched that. And so you could have said the DNA couldn't exclude the defendant, or the DNA evidence couldn't exclude the defendant, or the DNA evidence was consistent with this being the defendant's DNA. But that's not what he said. He said the defendant's DNA was on the victim's body.
And I think that's a reasonable inference from all the evidence when you view it together. But to the extent I am wrong, and then this court would find it's not a reasonable mistake, there couldn't be no actual reversible error here. The jury asked for that specific testimony. That 1 in 9 testimony was given as the readback. So the jury knew exactly, post what the prosecutor said, exactly what the DNA evidence proved. And they didn't just rely on the prosecutor saying this is DNA. And also the evidence in this case was overwhelming. For all these reasons, the state would ask that you affirm the convictions in this case.
Any further questions?
If I might, Chief, I found it here. The statute actually says intends to commit such crime but fails in the perpetration thereof, or is prevented or intercepted in executing such crime. So a voluntary abandonment would be a failure
Yes.
to commit, and why would you call that a failure to commit when he didn't fail? Just
He did fail. He
Stop.
started to try and rape her, and then he stopped. He failed.
There was evidence about her preventing him as well.
There was also, she tried to grip her legs together so he couldn't do it. So we also had the prevention.
So if you decide to embark on that chain of events, actions by the defendant, if you take one step and then say, I think I should not be doing it, I quit, that's still an attempt?
You'd have to have a sufficient overt act. It's not just any thought that you have about
Well,
the crime.
that's what I said. I'm going to commit this criminal act, and there are 10 steps I need to complete it. You take the first step, and then you say, this is not a good idea, I'm going to quit. That's an attempt to commit that crime?
I think it's going to depend on the factual circumstances. Here, he went far above a first step. He's taking her shirt off, he's kissing on her, he's trying to pull her pants down, he unbuttons her pants, she's trying to cling her legs together, and then he stops. That's attempted rape in this state.
But I understood you to say if he voluntarily quits or abandons, that's still an attempt.
Well, he did, after that, decide that he wasn't going to, apparently. He gave up. I don't know why he gave up, per se, but he did.
other than he found out her age. But that really isn't the facts that you mentioned and the preventing and all that doesn't really come into where I'm headed, because the prosecutor said it doesn't matter why the defendant stopped. The argument is it never matters. If you do an overt act, then it doesn't matter why the defendant stopped. And I'm just saying, when you read the statute, it doesn't say committed overt act. It says a committed overt act, and then goes on further. So I'm trying to understand why that is true under the language of the statute, especially if you use strict construction, as we're to do with a penal statute, that you make the rest of the statute superfluous.
Well, it says fails or is prevented. That fails has to mean something other than, well, I don't know if it's options within a means or something, but has to mean something to not be superfluous besides just was prevented. And fails could just be he stopped. Seeing no further questions, thank you for your time.
Thank you, counsel.
One issue that I did want to touch base on is the issue of the cross petition.
The what?
The cross petition, I'm sorry, Your Honor. And it is our position that if they have an issue with a finding of the Court of Appeals, even though they may have won the war but lost the battle, they need to cross petition. And this court has repeatedly said an issue not briefed is abandoned. And here they have never, this court never briefed the issue of why the Court of Appeals was wrong where it found errors in this case. And further, when we are filing petitions for review, and in my petition in this case, an example, I don't dwell on re-arguing that the instructions in this case were an error, because the Court of Appeals found that. My argument focused on whether or not it requires reversal. So we believe that the state does have to file a cross petition if they take issue with some of the findings by the Court of Appeals.
What do we do with the issue of I'm curious of your take on this, when the record is silent as to whether your client was present at a particular proceeding where his presence it's a critical phase of the proceeding, presence is required. It just seems to me what occurred here and what occurs in a few instances is that the district court just fails to make a record. I mean, it becomes pretty automatic. We're proceeding now, so-and-so is present, defendant is present with counsel. It's almost, and when that colloquy doesn't happen, when that kind of introduction to what phase of the proceeding doesn't happen, does that mean the defendant's not present as automatic error? How does that get addressed on appeal when we discover that that isn't there, that there's an absence in the record that notes the defendant's presence when in fact he's there?
I think this court.
Or how do we deal with that?
Sure. I think this court, in taking the position that if it is silent on the record, the presumption is my client, the defendant, is not there, is the correct approach. And it is incumbent upon the district court to ensure on the record that my client is there and present at critical proceedings, because we are dealing with the constitutional right to be present.
Even though he's there?
Even though he's there. The court needs to do that to make a clear record.
It's such a fiction, though, that we're going to find error, perhaps reversible error, when an error didn't occur. The error was the court didn't acknowledge his presence or her presence.
The point of making sure the court states that on the record is so it is clear. So we do know clearly that my client was there during the proceeding. And this case is kind of a weird case in that respect. But it's imperative that my client be there. We all, I think, agree with that my client has these constitutional rights to be present.
Agreed. And his right to be there was satisfied. Let's just say, in this instance, he's there.
Correct. But this court is a court of review. And what this court works off are transcripts and records. And that's why it's imperative for the district court to ensure that it's on the record. And this will have the secondary thing of ensuring my client is there. There are times where the district court doesn't note it because he's not there.
That's right. That does occasionally happen. But in this instance, let's just, for argument's sake, let's say your client was there during all the proceedings, and it's not noted. We find error, and perhaps reversible error, when in fact there was no error.
I believe.
That the error is it wasn't noted.
I believe what you do what the Court of Appeals did, and that is because of the issues and how they handled the proceedings. You go on the record of the trial, which is silent, and you assume he is not there. It may be kind of this weird circular argument where we're talking about an error when there's no error, but I think the court has taken the right approach in presuming, if the record is silent, that my client is not there.
No one at the trial level on a felony should be confused about the fact that ordinarily the appellate defender's office will be handling the appeal, and that attorney was not present in the courtroom, and that the appeal will be taken on the record. So that's almost every time your preparation of the case is based on the record before you, because you were not in the courtroom.
Correct. I mean, that's how we divide things up in this state. Standard operating procedure is the appellate defender office handles. You guys see us a lot.
Well, I'm not suggesting you're at all. Yes, you should bring it to the attention and argue your position, but
You described it as a presumption. Is it a rebuttable presumption?
That's what the case
I would
says,
say
isn't
that
it?
it would be a rebuttable presumption.
How can it be rebutted then?
From
your perspective, what would be the proper way to rebut that presumption?
I think the proper way probably would be there is a procedure to, I don't know if this might be a little bit of a square peg in a round hole, but there is a procedure to correct the record if there is an error in the record.
How would that happen if the lower courts no longer have jurisdiction?
I would assume, I actually don't know that I've ever filed such a motion, but I assume there would be some type of motion to remand where all the parties are obviously present to iron out what the
So you think
record
it just
say.
in the theoretical universe, a remand could be appropriate?
You know, this court does remand in certain instances. The one that comes to mind is Ortiz hearings. So, you know, to correct a record, in theoretical sense, I could see that happening if there is an issue with the record.
But we require defendants' contemporaneous objections to be on the record, don't we?
We certainly do.
Even if they said it at the bench where the record wasn't being taken, too bad. We
Certainly.
gotta make the record.
Yeah, and there are other times, and going to, you know, how to handle this case, whether or not there's actually an error or a presumed error. Certainly there are, Court of Appeals ignored the hearing that was done to purportedly correct the record. This court oftentimes ignores facts in making determinations on cases. So I think what the Court of Appeals did in this case was accurate and look at the issue, presume the error based on the silent record, and determine from there whether or not it's harmless.
Any further presentation?
No, Your Honor.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.